Meine sehr geehrten Damen und Herren, liebe
Ladies and gentlemen, dear experts from the tourism industry, welcome to our panel on the subject of the new EU Package Tour Directive. This session will be mostly in German, and yet we have provided interpretation services for our international and English guests. Now, let me please first introduce the members of our panel to you. From the ITLN, the International Travel Law Network, was responsible for composing our panel. Let me start with our charming co-host. She's the editor, Nadine Kassian from the FOV, and she is responsible for legal affairs, cruising, and e-commerce in the Tourism Authority. And she also studied law, so she is an expert in these matters as well. And then to my left, now from your point of view, of course, I would like to introduce Dr. Kressel. Dr. Kressel is head of the legal department of TUI Deutschland AG, and at the same time he's also the president of the DRV Legal Committee. And in this function he's played a very important role in the lobby work of the German Tourism Association with a view to the EU Packaging Tours Directive. And then I may also welcome Stephen Mason, senior partner of the Travel Law LAP, which is, and he is a renowned expert in the field of packaging tour law, and he also wrote a book, the title of which is just as well known as the standard the standard book in Germany by Professor Fürich. And they call him Mr. What is a Package in Great Britain, actually. And he will be our expert for questions of the implementation of this directive in Great Britain. And next to him, Dr. Ernst Fürich, who is himself a professor for tourism law at the University of Kempten. And of course, we all have known him for years because of his numerous publications on the issue of tourism law and travel laws. Then let's skip Ms. Katzian. Then there is Professor Klaus Tonner, who is a professor for European tourism law and travel law at the University of Rostock. And he's also the author of numerous books on this matter, but not only on tourism law, but also on consumer protection. Professor Tonner is very active in this field all across Europe. And next to him, Mr. Michael Buller, as head of the Association for Internet Tour Operating in Germany. He is now the representative of the online part of our industry on this panel, and he's always good for a quote in the press. And then I would also like to welcome Mr. Frank van der Waal. He is the CEO of a startup which will go live in 2 weeks' time, and they look into a very interesting aspect, and that is the secondary trading with packaging tours. So if you don't cancel your package tours, but for example offer it to another potential client through a portal, creating a win-win situation for everyone involved. Of course, always on the precondition that the operators and everyone involved goes along with this with a view to costs and risks. So after this introduction of the panel, I may now introduce for our introductory speech on this rather difficult subject that we want to not only discuss in controversial terms, but also in a rather relaxed atmosphere. I would now like to welcome our Permanent Undersecretary of State, Mr. Gadbin, from the Federal Ministry of Legal Affairs and Consumer Protection. And he, in his ministry, is responsible for the German implementation of the EU Package Tour Directive. So in that respect, they have already started working on the implementation of this directive. And we're very much looking forward to the recent information that you will provide us with. Thank you very much, and come on stage, please. Mr. Siebert, Ms. Kassian, ladies and gentlemen, I was glad to accept the invitation to this discussion and to give a speech, because with the implementation of this directive on package tours and associated services, this is a great challenge that we will have to face. And currently we are still dealing with the implementation, and so it's, I think, a good point in time for us, before we finalize the draft proposal, it's a good point in time to sit down and exchange our views on possible ideas and improvements. I don't think that I need to lay out the details as to how this development came about, but in the end, we have a result that is compatible to most results on the European level, because we're talking about a situation with quite a large number of member states who have differing interests, and then there is the European Parliament and the European Commission as players. But I think that from the German point of view, we managed to actually get some of the things being acknowledged that are of interest for us, and we also managed to avoid a couple of things. We always thought that effective consumer protection should be combined with simple rules of implementation. But of course, we seemed not to have been fully successful. Otherwise, we wouldn't need this panel here today. I would now like to talk about a couple of things that are not new to the German travel market, like, for example, being able to hand over the contract to someone else, and the question that, unilateral changes of prices or other contractual conditions will remain possible. And there are also many known regulations on the cancellation rights. I think what's more interesting is if we look at the leeway, the room to maneuver we have in terms of implementation here in Germany. What are the critical points? Because we still have a little room, leeway for implementation. We, for example, have an opening clause for a clause for contracts that can be withdrawn or revoked if they are not concluded in businesses themselves. And this also is true, for example, for tours or other outdoors activities where you conclude these kinds of contracts. Now, what else is a matter of discussion? Additional costs for being transported back to your home country. That is new. What's new is that the tour operators always have to carry the extra costs for the fact that tourists have to be brought back to their home country because of unforeseen events. So there is no differentiation whether the trip is now cancelled or shorter than planned because of force majeure or because of other unplanned events. What is also new is the extra cost regulation for lodging. If the passengers cannot be taken back to their home country because of unforeseen events, then the additional costs will have to be borne by the tour operators for at least 3 overnight stays, or for up to 3 overnight stays. There are also some novelties with a view to price changes. The directive now quite clearly states that the operator reserves the right to price changes only if the traveler has the same kind of scope for receiving a rebate of the price. And the threshold from which onwards travelers can actually declare their contract void is also increased. It's now 8% instead of the 5% in the past. I think what is most controversial in terms of the changes is concerning travel packages, or package travels rather, and additional services. We now have a European definition of the package travels and the associated services. The package travel is, according to the new definition, not only the traditional pre-packaged tour by the tour operator, like, for example, a round trip from the catalogue, but this definition also comprises tailor-made tours, that is, tours that are tailor-made according to the wishes and desires of the traveler. And this is also independent from the question whether the booking was done through an online booking portal or in a normal travel agency, a physical agency. Both are distribution points according to this directive. The associated travel services are a new category. This is about a case where the tourist would not book a package tour, but has at least two different kinds of touristic services in the same trip that are being booked. And the directive now says that either you booked this tour in a single visit to, for example, a travel agent, that is, you only had one single contact with this distribution point, or the tourist would book only one specific service, as, for example, a flight. And then he is being brokered an additional service by another operator or provider. And after booking a flight, that could, for example, be the booking of a rental car. The precondition is that within 24 hours, a contract is being concluded with the second provider. The criticism that we received from the online segment so far pertains to the question of what it actually means that an additional to a service is being offered in a targeted fashion. That is too unclear, and it's not quite clear when these conditions are being met in the case of online advertising. But we don't think that this is a term that needs to be concretized in a legal framework, and this was also debated in an implementation workshop of the Commission together with the other member states. And the Commission held the opinion that a mere advertising is not a targeted brokering service. And this is something that the courts will have to put in rather more concrete terms. So I think that the result of the voting here in this room was rather realistic. This is something that needs to be clarified by courts later on. In terms of physical travel agents, they pointed out to the difficulty that booking everyday work cannot always be judged based on the necessary legal preconditions, whether, for example, a travel service is being offered or whether a package tour is being assembled. And this is, of course, a question of definition that does not only concern the travel agencies, the physical travel agencies, but also other suppliers. I'm not going to deny that this regulation, or this directive rather, is something that is not easy to understand for the members of staff of travel agencies or online tour operators. And from the consumer's point of view, and also in the interest of everyone involved, I would have wished to have more clarity in this field, because we now will have to find a kind of procedure that helps us to live up to the requirements of the directive. And for that, we need to develop a certain, amount of creativity with a view to interpreting how things are being offered and sold. But I think that the directive in itself is rather clear. In delineating things, it is about whether the customer really picks all the different elements of a tour in advance and then agrees to pay that. That would be a package tour as a result, or whether the consumer picks the individual services one after the other and pays them. Then these are associated travel services. What is also important are the online booking procedures, the so-called click-through bookings. And here it always depends on whether the first entrepreneur, for example, transfers certain data to the next suppliers. And there is also a duty now to have an insurance against insolvency when you broker travel services. We tried to limit this kind of obligation in Brussels, and I think that the result is really acceptable in that sense that the directive now stipulates that the brokers of associated travel services only need to be insured for their own services that they offer. For travel agents, that means that in the case of brokering, they only have to be insured to the amount of payments they received. And if the operators receive the payment directly, you don't need to have an insurance against overall insolvency, and the same goes for online tour operators. There are two more points that have not yet been fully clarified, and we're still discussing these, and that is the question of what kind of assurance we want to have against insolvency. There is a little leeway here, and we are still debating as to how to implement this in Germany. And the directive also does not really clearly say whether the travelers have to explicitly agree to substantial changes to the contract or not proposed by the tour operator. So we are still working on our draft proposal in that respect. And we plan to finalize this draft proposal in spring. So I think this today here is a very good opportunity indeed, together with the members of our panel and together with your questions, to try and gain some further insight and collect some information. I think that this regulation, in spite of all the criticism, actually represents something of a uniform approach on the EU level. We've got a uniform protective framework, but now in the implementation phase, it is of course important to pay attention to making sure that we have procedures in place that can also be put into practice. So I'm looking forward to your proposals, and thank you for your attention. Thank you very much, Gerd Billen, for this introductory statement. And our vote here in the hall also showed the fact that there is still an amount of uncertainty. I hope that we'll be able to shed a bit of light into this dark area, if you will. So let's start by asking to whom does this directive apply? The Council and the Commission were not really could not really agree on that. There is one disputed point, which is business traveling. Mr. Führer, what do you think of the compromise that has been reached? Well, first of all, I would like to apologize. I have a cold, but I hope that you can still understand me. Well, this directive is not a consumer protection directive. So this is not directed to consumers, but to travelers. And a traveler is everybody who's, traveling. That is also a business traveler. The directive was based on the idea that it should also apply to the small business traveler, if you will, who would choose the normal booking channels. They should also be covered by this directive, and that is why this directive does not really look at the purpose of your job, whether you're doing it for leisure, for relaxation, or seeking for adventure, or whatever. But, business travels are also part of this, and with one larger exception. If you've got a framework contract with an operator or a provider from the travel business, and if this framework agreement is a contract, then you've got a business-to-business kind of contract, which means that on the one hand you've got the company customer, which is Siemens or BMW, and on the other end you've got the tour operator or the service provider. But let me add right away that you normally book hotel overnight stays, which is an individual travel service. And these kinds of individual travel services are not covered by the package tour directive, like, for example, hotel bookings. And, I can also tell the airline representatives who might be here that they can calm down, because if only a single flight is being booked, then this directive does not apply either. So you can see that the area of use is rather limited. Well, it sounds rather clear. If there is a framework contract, then it's okay, and because you say that the company does not need this kind of protection. But the question is, when are we speaking of a real framework contract? Well, if you book, for example, via HRS, and if you want to be a company customer, that you have to enter your revenue tax ID. And then I think that would be really the first step. So we should not really think of these requirements to a high level. I mean, you're being treated then as a customer, a company customer, and you're being offered special rates. And I think that is enough that would make you qualify for such a framework contract. And actually, the directive does not mention the word framework contract, but just an agreement. A framework, an agreement could be something like that. But this is, there we won't encounter too many problems with this directive. But now I would like to ask Mr. Buller whether he agrees with you, because as a representative of the online companies, he may not be too thrilled about the idea of every booking at HRS or Expedia, who are also cooperating with many business clients, that they would be covered by the directive or excluded from the directive. So I think it's a difficult question for the onliners, isn't it? Well, yes, it's not that easy to give you a clear answer, because as a rule, people don't buy just a single service. If you look at the new startups, it's always about simplifying a whole lot of things, simplifying processes. And part of the business trip is, a flight. And on top of that, in most cases, you've got a rental car. So you've got two services already. And now it depends on how you purchase these and whether you've got an overnight stay. And that's where things start getting difficult. And Mr. Pill just mentioned that that we also had some discussions about the use of advertising or targeted advertising. Now, of course, we could say that this is a question that the courts need to clarify, but there is Article 19.3 that says that if you misinform people, then you've got the liability of the Package Travel Directive. So, which means that in an unclear case, for example, you've got a banner on your website, and of course, this is also a source of revenue for some portals, and this banner may lead to a kind of travel service, but you did not inform the customer about that, and you don't even know that the customer purchased an additional service through this banner, and then you are liable according to the Package Tour Directive. Suddenly, and it's not really about trying to sabotage this rule, or undermine it. But, we just want this rule to be very, very clear, like this 24-hour regulation. We also need to know what kind of information we have to provide or have to have in order to know whether it's a package tour or not. We don't want to relive the kind of disaster with the business tax, where we had a 6-year discussion whether it was intended like that or not. And I don't want to have regulations from the European Court of Justice or wherever. I just want to know what I can do and what will lead to what.
If I may pick up on this, the desire to have clear regulation is obviously very important. When we go back to questioning the audience, which we did a moment ago, that also indicates that quite obviously players in the industry want something else. That clarity is not agreed through legal implementation, but rather comes about because of rulings made by judges at different courts. And that brings us back to what the Under Secretary of State said, the new definition of the Package Travel Directive. And in its way, that also comprises combined travel offers, because the ECJ had a ruling on club tours. But of course, the definition has also been extended in the new Package Travel Directive, and it comprises some novel features. Exit bookings, i.e. combined booking cases, offline booking and online booking of different types. We have two representatives of that industry with us here. Stephen Mason is one, and Stefan Führig, Professor Dr. Ernst Führig. Both of them probably know a lot about this. So a question to you is, what do you think about this new definition and terms such as whatever you offer in travel has to be subdivided into different modules, and these modules have to be explained before payment agreement is given, sought or given. Is that something which is too complicated? Because looking at travel agencies and the way they work in practice, isn't that rather difficult? I mean, yeah, agree, yes, I will pay, and suddenly you've got modules which aren't available or can't book, but you've already agreed. So what is it? Is it a valid contract or is it not that you've signed there? So my question is, this new definition in general terms, are you happy with the way it's been defined now, or are you not happy? And do you think there are risks coming from this new definition? Perhaps we'll start with Stephen Mason.
Well, I think the definition of package is actually not too bad. If the agent has made, the travel agent has made the mistake of letting the consumer think that everything is already booked and ready for them to take up as long as they just pay for it, then there is a contract, and then there will be a package if it comes within the definition, which it probably will. But if, on the other hand, the agent makes it clear that it's not finished yet, it's conditional, he needs to check that the flight or the hotel are actually available, then it seems to me that there isn't yet a contract, or at the very best, there is a conditional contract. And so I think it depends on the reality of what's actually happened in the discussion.
Herr Professor Führig.
Professor Führig, what do you think is the German view? Valid contract, yes, no? Is there a hang-up or a bottleneck if people have agreed to pay, but suddenly a module is not available? Well, first of all, I need to apologize for the horses in my voice once again. In general terms, my opinion is that the direction of the new directive is correct. That goes away from this subjective impression which customers have, because currently the German Civil Court says you have a combined travel booking of two different types of bookings, and is that then simply a travel agency job, or is it already a package tour? That was in the past. Now, the new directive changes things. It's a change of paradigm in a way. It looks at the booking situation, and the booking situation, basically that's an objective criterion, and if you have objective criteria, then in general terms it's always better. But of course, it does invite misuse, so that people will try using sophisticated little nooks and crannies, using the new media to make this a package travel which you try to leave behind. I mean, the original intention of the directive was that the area of application should also be extended to involve the new media. That's the old package travel didn't, but the new directive does at least intend to incorporate the new media. Whether or not it'll be successful in that, we'll have to wait and see. We do have click-through bookings as well, because that ultimately is a package tour too. And then there are these disastrous regulations of 24 hours, which technically is very easy to avoid. And we can, I mean, I'll hand over to the other guy who's trying to say something all the time. Klaus, what do you think? Well, I would like to put forward another argument and look at it from the point of view of the travel agency. Obviously, the idea is they have to make sure that a package travel is not diluted from all the electronic bookings, that there is still an area of application for what they're doing in the travel agency. But of course, the package travel directive must not be so far reaching that there is no room left for the travel agency to do the business. That has to be possible. And that's why the wording of the directive is based on a compromise. And as we know, a compromise is always very difficult to actually implement. And I think it'll almost certainly mean that the legislator, which will have to implement the directive into national law, that is not something you can avoid. So ultimately, it'll end up with the courts anyway. I'm pretty sure of that. But in Germany, I think we can live with the way it is, and the Federal Court of Justice tends to be quite good at interpreting things properly, although let's not forget it's not the German court, but it's ultimately the ECJ, the European Court of Justice, that will decide. So let's give you a more concrete example. The travel agency will try not to assume the role of the package tour operator. So you have to be very careful. They can't write total price on it or package tour, because then the liability will rest with the travel agency immediately. But legally, you can avoid that. That's not a problem. The real problem, I think, is the third option, which also exists, which, according to the directive, will make a travel considered to be a package travel. And that is if within one booking process, different combined travel services are sold. Let's assume you're sitting across the desk from somebody at the travel agency. The travel agent sells you a hotel. You say, great, but I have to get there first. So your trolley hasn't been completed, or your shopping basket. So you add the flight. And then suddenly the travel agency has become the package travel operator, or at least liability is as if it were. Let's say I'm a lawyer and my client is a travel agency, and they ask me, what sort of liability do I have to incur? And then I can say, well, my dear friend, you can tell your clients, we book the hotel and then we do this, and I print the invoice and I put that next to the other papers. Or if it works online, we do it. I mean, first of all, we go through that, and then now buy function has to be bought, and then you see. So basically, you finish that, or you go out again off the particular program. Yeah, well, that's up to the customer, of course. But you send the first element. You can also send the customer home and says, come back in 3 days' time, and then we'll do the rental car. That's not exactly practical, because the customer will say, well, wait a moment. If I say you have to wait, the customer will say, no way. So from the point of view of making the sale, it's almost incumbent on me to do what ends up like a package travel. So the travel agency will act like a package travel operator. Well, the click-through bookings, this ominous type of booking has been mentioned before. That's a term which has really only gained ground in Germany once the EU passed the new Package Travel Directive. There used to be lots of different directives, online, offline, liability. Combinations were quite difficult, but the idea was to make sure that everybody enjoyed the same rights. Question is what to do with click-through bookings. They're sort of combined travel bookings, if you like. But I'm asking you, Mr. Buller, what about your onliners? Is that a huge problem for them, or do they get out of the problem quickly? Well, it looks as if anybody who does online selling tries to evade responsibility. That may be true for some markets, maybe even for the EU, but I don't think so. Look at Connex or something like that. They're doing these sort of things for years. They work like an operator. They take care of the guest when on the spot and so on. What I tried to say earlier is that when we saw the development of package travel, I never was worried about the OTAs, the online travel agencies. And if you have an OTA in Germany today, well, a good company will make something like 600 to 800,000 euros. Maybe it's a few million if you work internationally. Well, these organizers have got the money to set up proper package travel, which does always have more risk. If you've got a flight which you select and then the airline goes bust, which can happen after all, then the problem is with the guests always. But if you do it as part of a package tour, then you are liable if you have organized that trip for your guest. And if you're a large-scale OTA, you can live with that. You survive it. Question is, what about the smaller travel agencies? Because then they have to keep to the same rules, which basically makes sense because the package travel never looks at a distribution channel, but at the sale of travel, which it still does. But I'm looking at what happens to medium-sized companies. What do they need to do now? Basically, they have to go to cooperation partners and say, you help me find an operator and help me build up the international structures which I need, plus all the other things like providing medical care on the spot if somebody has a cardiac arrest or whatever. So the OTS, always supposing we get clear instructions from the legislator as to what is allowed and what is not, we can handle it. What worries me far more are the medium-sized travel agencies. I mentioned that 2012 when we looked at this. The OTAs will sort it. But dear travel agencies, you look at what is likely to happen. I mean, when they woke up, it was a bit too late. Well, perhaps that's a question we should hand over to Dr. Kressel. He is somebody who is at home in the online and in the offline worlds. Many times we've been discussed the various ways of avoiding issues. That's part of the directive because of the online booking trips, the way we've defined certain things like email payment, form of payment, address. This sort of thing is already a problem, especially for those who don't want to have these sort of problems, particularly for TUI. You really have problems, or will you be able to work at a high level? And will stress factors arising out of circumvention attempts, won't they happen? Well, no, I don't think circumvention is likely to happen a priori. We cannot assume that will happen. We shouldn't do it either because it's not a genuine solution. What we have to do is find a proper solution, a way of handling the problem. Because let's understand, this whole click-through issue is not something which was created in order to provide circumvention in the legal sense. It was actually one of the big drivers for the whole reform of the Package Travel Directive. That's something which has been moved to the background because so many people criticize the new directive. And I think it's going to be very important what the German legislator makes of it all when translating international law. But we didn't mention distribution earlier. From the point of view of an operator, travel operator, I have a slightly different view on that, particularly because I am the one who wants to be sold. I mean, if my tour doesn't get sold, I have no revenue. So I need to have clarity, ideally legal certainty, that goes without question. But where there are problems or gaps, and there where I agree with what was said earlier, maybe courts will pronounce and provide the clarity that we sometimes lack. But nobody who I hope is an agent who sells me as a product will wait until in 3 years' time a court will sort it. The agent will want me to say today how it works. That's going to happen in practice. And if I can't do that, as a travel operator, then probably my product won't get sold. The agent who's faced with a customer will not grab my brochure out of the shelf behind him or her, but the one from my competitor, and I don't want that. So as far as I can, I'll have to clarify the situation in the interest of the travel agent and ultimately probably in the interest of the guest and would-be passenger as well, because otherwise I won't get my product sold. Okay. Regarding definition and the question to what extent the national legislator will provide clarity when implementing international law, whether it's the court, we will wait. But Stephen, what about the UK? Clarity?
Obviously, this is a maximum minimum harmonization measure, so there isn't much room for manoeuvre for the member state governments. So the UK, of course, always goes for maximum implementation of all European legislation and then complains about how difficult living in the EU is. But I just want to say something about this question of ambiguity in the definition of package. Of course, there are some areas of ambiguity, but I think I can predict fairly confidently which way they will be decided, because in what forum will these issues be decided? They will be decided most likely when somebody a customer, a consumer, is injured while they are on holiday, perhaps seriously injured while they are on holiday, and they bring a claim against the, we'll call tour operator, and in order for the judge in the court to give that badly injured consumer compensation, all the judge needs to decide is that this ambiguous wording means that this was a package on this occasion, and then the judge can award compensation. Now, certainly in the UK, most judges will lean towards awarding compensation to injured victims if they possibly can. And so I think that any trader who is taking a very serious risk, if they assume that because the wording may be slightly ambiguous, that means they're not selling a package and they don't need to worry about regulation, they don't need to worry about liability, I think that will be a great risk. And so I think we can assume where there is ambiguity that it's best to assume this will be a package.
Okay. Bevor wir Sie als Publikum
Now, before we involve you as the audience, when we will ask you whether this directive has done what they wanted to do as a priority to achieve a level playing field between online and offline agencies. Has that been achieved? But before that, Ms. Cassian, we talked about force majeure again, and that's another definition where the content has changed, because force majeure is something which seems to be disappearing from the directive. That is so. Force majeure was something we talked about when people could decide not to take the trip without having to pay for it. And now we have inevitable extraordinary circumstances, quote unquote. Now, what could constitute just that? Mr. Tonner, he's always somebody who really knows about definitions. Could you tell me what is an unavoidable extraordinary circumstance? Only in case of travel, please. Well, the word has probably got round that the legislator at the European level have introduced this because the air passenger directive already includes that term, where it has caused a wealth of problems. And there are masses of rulings by the German Federal Court and by the European Court of Justice relating to that very question. However, these various rulings have also clarified the issue somewhat. We no longer can say that nobody knows what to imagine constitutes an unavoidable extraordinary circumstance. And this legislation now will have to be adapted to the wording in this new directive as well. But the directive does make it a little easier, because we don't just have the actual words, we also have the deliberation, because they list some of the cases which were used. And you notice that the official from the relevant Council working group have done quite well, especially the people from the German Ministry of Justice have put forward some German examples which would help us. So I would like to put your mind at rest a little. Adopting these new terms probably is going to be a great deal less difficult than it may have seemed at first glance. We should also say that the Federal Court of Justice in Germany has come a very clear view, and we're already using that term in rulings which are being pronounced now. In the past, we always said a strike is a quarrel or a dispute or a strike is only force majeure if it comes from outside. If it's air traffickers strike, for example, then it's force majeure. If it's your own pilots, it's not. And I think we can live with a new definition now according to how the courts are pronounced already. Well, you know such terms as well. You're actually writing a whole book where you explain such terms. How would you interpret this? Well, I think I would agree with Klaus Tonner. After we've got lots of people from the industry represented here, let me also point out once again that the term force majeure is quite important when it comes to cancellations. In other words, basically when you cancel a trip, but also it's important when it comes to damages being awarded because liability is at issue. And now we have a more narrow definition, the extraordinary circumstances, quote unquote. And the Federal Court of Justice in Germany has pronounced when it comes to the rights of air passengers, where the same term is used, that an in-house strike action, in other words, when your own pilots go on strike or when your own staff go on strike, that is no longer considered to be an extenuating circumstance. In other words, you are no longer liable in such a situation. In the past, when your own people went on strike, you always had to pay full damages because you were fully liable. And if it's your own people, that has now changed. And so it's going to be a very major impact that it will have. When we're looking at the EU legislation and rules, we will see that we will end up with a more uniform interpretation of what these terms mean when all passenger rights are concerned. And never mind whether we're talking air passengers or whether we're talking cruise ship passengers, whether we're talking passenger rights for rail travel. And in future, the Package Travel Directive will simply be one of those passenger rights directives, gaining clarity for us all. And I think that's something really good for the industry, because it means we no longer have to be liable for the strike of your own staff, because your own people have the right to strike. They can call industrial action whenever they like, and we shouldn't be sort of criminalized for that by having to pay damages as a result. I'm not talking about people being able to reduce the fare or whatever. That's another issue. Okay, let's ask the audience once again to vote on a question we ask you. The new directive, among others, wanted to put OTAs on an even footing with other agencies. Do you think, yes, that they've succeeded in doing so? That's one. Two, they have partly succeeded, and C or three, depending. No, there are still different rules that apply, so they have not succeeded. So one, yes, two, partly, and three, no. I can see partly seems to be the majority. So at least that's something, but quite a number of you say no, they have not succeeded in putting it, making it a level playing field. That's a bit sad for the directive, because that was the very reason why the directive was drawn up in the first place. Okay, well, let's take this opportunity to move over to confirmations, i.e. the confirmation of the contract for travel agreed upon. There are also different extended notification obligations which have given new emphasis to confirmation in this directive. And possibly it means that the systems of our operators will have to cope with new IT challenges as a result, because the new confirmation, which the directive now demands be put in place, may well be a great deal more comprehensive and involved than there was in the past. Not even talking about clarity and whatever. I know GDS codes, basically, but a sort of legend-free travel confirmation, easy to read and comprehend for the consumer. That's the idea. Another question is, of course, all the things for which you used to simply provide links and so on for offliners. Do you now have to incorporate all of this into your terms and conditions? Well, if it's relevant for the contract, if it's part of the subject of the contracts, will you in future have all that incorporated in the confirmation? And another issue, which is sadly specifically German, do you have to have a sort of certainty declaration or not, a guarantee, or can you say, no, that's enough, you simply say who provides the guarantee? Dr. Tui, you come from practice. This new travel confirmation we can expect. Well, obviously, if you're dogmatic about it, everything has to be included in the travel confirmation, but you do need to also ask what are the media that I work with, or what the marketing people always say, there is a sort of rupture in the media. What do I do orally? What do I do in writing? What do I provide links with? What do I make accessible everywhere? And by the way, not everybody has internet access these days, even that is true. And yet, I also must understand that I may go beyond what is necessary, or simply put, if I write too much into my confirmation, I may end up with a sort of phone directory thick confirmation, A, which nobody will understand, B, nobody would even read it, and third, if you want to really drive the travel agencies mad, then that's what you need to ask them to do. Now, that would go far too far. Just the volume involved. I mean, all this will have to be printed. It's not just time we're talking about cost as well. Because all these apparently so unimportant things, when you're looking at the details, that's quite important. I mean, if you have a well-organized travel agency, maybe they can work some of these things out, but it still costs a lot of money. So we have to find a sensible way of what can be done, what is practical, what is also understandable, and what is something which is still something which people can understand, can follow also by volume. Because sometimes even now, certain terms and conditions, you have to click through your way, and you click every paragraph or every second paragraph. And now, in order to make that visible, you have to put lots of that into the travel confirmation. I can understand that, may make sense. But the more I write into it, the more information people will have to process. And at some stage, it becomes more than people can really comprehend. So a word of caution. Well, maybe this whole new issue of standard information, which is also mandatory, which has to be a sort of supplement of the confirmation, for which we have 5 different versions, A, B, and C. I really like to see how the various travel organizations do that and differentiate properly between A, B, and C. Maybe for TUI it will work, but thinking of smaller operators or online travel agencies, in practical terms, I think we're going to see quite a few problems when it comes to getting the right version of the standard information to the consumer. Maybe I can answer something on that. I would basically agree with you, but I think the OTAs may have a bit of an edge here over others because they have to be clear about this and have to sort exactly which product or which query requires which information notice. We've got lots of them also in the annex of the directive, after all, which will all have to be taken over international law. When I can do that cleanly and clearly online, it may be something that makes distribution easier. But it's much more difficult when you think of the poor little girl or boy in the travel agency has to say, oh, God, which sheet of paper do I add here or there? So I think the OTAs and all operators and agents will be very much asked to make it easier for their staff so that they can handle that issue. Professor Fürich, the travel security note is a big issue for you, isn't it? Well, you always think of the agents, but, I mean, wasn't it the same in the past? The poor person in the travel agency used to sit at his or her desk and thought about, which terms and conditions are this, or which tour operator has which terms, and what is it that the customer needs? Often it was a bit of a clearinghouse for different terms and conditions. But that was just, done away with by the directive. They just want to turn a contract into a contract, if you like. I always said the travel confirmation is a pretty stupid word anyway. If you have a sales contract, that's what it says, sales contract. So you could also write travel contract. but now we probably call it the package travel contract. And that is supposed to have all the various things regarding the legal obstacles or the subject matter of the travel you book. In the past at ITB, we used to sell that in such a way that we told tour operators, oh, it won't be that bad. You can just, slim it down until you have something like an ordinary invoice and you just put it in terms and conditions. But now the directive states very clearly that we have to provide the right information to the customer. So it should be part of the contract that what is the total price? I mean, I'm always somebody who loves criticizing, and here I would like to do it again. The industry really doesn't understand that we want to communicate and have to communicate what the total is, with all the obligatory subtotals. That includes a service charge when you go on a cruise and what have you. So, I mean, I don't want to name the shipping companies here. I'm sure many of them are here, but they always act as if they don't know it or understand it. They always say, well, it doesn't concern me. But no, I do expect everybody, including the ministry, when it comes to national implementation, I want to make sure that the necessary details are all included and that the implementation law names them all, so that what you end up with as a total will definitely be a valid total, and that is the price the customer will have to pay, and nothing in addition. Professor Furyk, if I may pick up on that. It goes without saying that that's an issue which is leading us astray a little, total and so on. I would like to hear from Mr. Buller about this once again, because on the online, the summary page is a bit of an issue. In other words, just before I sort of click on confirmation, I know the details already. All the salient points are listed in the summary page and made transparent for the consumer, aren't they? Well, I'm a bit worried about the huge amount of data that we'll have to be sending all over the place all the time. I think it's going to be a bit of a problem, just how much information we have to provide to the customers. After all, one of the biggest lies in the internet is always this click, yes, I have read and understood the terms and conditions, because nobody does. Before we ask the audience once again, let me also ask Mr. van der Waal again, who is sort of hasn't been much involved, but you have a very interesting business model which you are starting with. You're saying you don't cancel your trip, you simply sell it on. Maybe quite an advantage for many travel agencies too. Perhaps you can tell me what this is like in law and what the new directive will say about that.
Thank you very much. So trade to trip is, as we already heard, this is a marketplace for end consumers who actually purchased a trip but want, instead of cancelling it, sell it on. But what's really very important is that the overall directive is actually geared towards protecting the consumer, and that is what our platform is based upon. You know, we want to help consumers who encountered a problem. And that's also, an advantage, of course, for the overall tourism industry, for the travel agents, and that helps them to really help their customers. And you don't see any legal problems coming up there. I mean, if you look at the law, and if you also take into consideration that we try to protect the customers, then no. But of course, on the other hand, there is the travel industry that also, of course, loses out a bit in terms of the revenues, and that also is important for the industry, for the airline industry. The yield management plays an important role. So if you, for example, purchased a trip 6 months in advance at a cheap price, and then later on it's more valuable, then of course they try to resell that ticket if it's been cancelled, instead of just sitting and watching as someone is handing it on to someone else. But if you really look at the intent of the law, it's about this is about consumer protection, and it tells us that even in the case of package tours, you have the possibility of selling it on to another customer. I can understand that the airlines, for example, would cause a problem here. But if you look at the intent of the law, and then I think you should just follow this approach. And there is only the additional cost in terms of the operation. Under Secretary of State, Mr. Bilge, this is very interesting for you. In implementing 651B. Which will also encompass the question of how and whether you as a tour operator can make this trip accessible to another customer. If, for example, in my package tours, I'm using low-cost carriers, dynamic packaging, and if there are cancellation fees, let's take as an example the airline that's using non-refundable fares. That would destroy the whole idea, wouldn't it? But, currently we've got German courts that say the only thing that you can pass on as a tour operator are the administrative costs. And they should not leave everything to the airlines that would say, no, we have to have a higher booking class, a new ticket with all the additional costs. That would actually, destroy this kind of win-win situation that you talked about. Yes, I would like to underline what you just said. We're happy to have Mr. Millen here on board because, the airlines saying, okay, we are airlines and the rest is of no interest for us. Fare you well. That is a problem that we've been encountering time and again. That is why I think we need a harmonization of the legal framework because package tour laws are rather clear in that respect already. That is consumer protection law. That's it, full stop. It's just very clear. And, I may name someone to take my place. I may pass on my trip independently of the question of what kind of problems this may pose to the tour operator. So this is, I think, very important to harmonize the legal systems in this respect because it is at this interface where the discussions start between the tour operators and the airlines, and these are by no means discussions that people enjoy. Before we now open up the discussion to the floor, or rather to the audience, and before we give you the opportunity to formulate some questions to our panel members, we would like to also come to speak about a couple of things that we normally would have talked about in our discussion, but unfortunately we are limited in time. On the one hand, there is the issue of price changes that will just be, carried over into the new directive, but from different perspectives. In Great Britain, the whole thing will be changed. We had a 5% threshold for price changes, and now in the future it will be 8%. Some tour operators will say, okay, that's wonderful. Now we've got a little more leeway. In Great Britain, this leeway is rather being reduced, and in other countries it's an entirely new. This is something that we'll need to talk about. Then there is also a clause for cancellation or for annulling contracts. And Mr. Bennett, you just mentioned how we deal with that in Germany. But again, there won't be a level playing field, as we say, in the whole of Europe. And for that reason, I think we may have to think about what these kinds of opening clauses would lead to if there were a full harmonization in terms of practical implementation. And then there are a couple of things about the additional liability of the operators, insurance against insolvency, for example, that people would not have to have that, especially in the case if they have an agreement with the operator that to pass the payments on directly, or if they have a kind of interim function administering the payments of the customer. So this would make this kind of insurance against insolvency obsolete for some parts of the chain. So these are quite a number of points that still could be discussed, just as well as the question as that of non-EU tour operators that are being offered through a brokering service within an EU member state, and how we deal with liability there. Because, of course, the American or the Australian tour operator, they don't have the kind of traditional assurances that we require here in Europe, and there it would be the brokering party who would be liability, and that should also be something that the people working as a mediator of services should be aware of. And I would also, like to have you to think about some of these issues concerning the package tour directive, and I would also like the experts to then, of course, in the end, come up with a possible solution to these issues. Are there questions now? If yes, please use one of the microphones here in the central aisle. Perhaps you could just tell us who you are. My name is Josef Schickert from the Tourism Association in South Tyrol. You know, tourism does not only consist of operators and OTAs. In our case, some 90% of the clients, that is of the tourists, do their booking with the hosts. You know, if someone's, come to South Tyrol in the Christmas season, then they'll do the booking for the next season right away before leaving. And we have an average of 30 beds per hotel or per hotel or hostel, and we of course try to make everything possible and as convenient as possible for our guests. So we try to book in advance the skiing equipment and a ride in a horse-drawn sleigh or something. So for our segment, I think we are really exaggerating things, because our small service providers would also be considered operators, because they are offering different kinds of services that they organize themselves and that also appear as part of the overall invoice for the customer. So in the end, these smaller operators might run into trouble. You know, they might have to have additional insurance and so on and so forth. So my question is, when I go back home, what can I tell the people at home in South Tyrol who are operators themselves how to deal with the situation in the future? Yes, you're mentioning a very important topic there. I'm an Austrian myself. I may tell you a little bit about the behind-the-scenes things in Austria here. The Austrians were actually the only ones who rejected the package tour directive, because they were afraid for their own domestic industry. And in Brussels, we hear that for a package tour, we've got two main services that need to be part of the overall bundle. And the precondition is now that you have, a certain scope of services that are being sold. So if you, for example, book only the stay in the hotel, then you, of course, have the normal contract according to German or Austrian law, and this does not yet constitute a package tour. But if there is a second package, and that is, for example, the wellness package with, which makes up 25% of the total, the sum total that the customers have to pay, or more than that, then, of course, according to the directive, and what we are implementing is being harmonized, and we can't do anything much about that, then the hotel owner becomes a tour operator. Of course, you can try and circumvent that by making sure that people just book the additional wellness package when arriving. But even for that, there are stipulations in the directive, and it says that you can't circumvent this by coming up with this kind of construction that you offer an option for next year's stay and offering to book the service when coming there next year. So I think this is really going to be a major problem. These one-off payments for hotels will turn into package tours if the individual additional services make up more than 25% of the overall sum total. Thank you very much for these explanations. And at this point in time, I may now just thank all of the members of the panel. I would like to also thank Ms. Katzian for taking on the role of the presenter here. Thank you very much also to our Permanent Undersecretary of State. It's by no means natural to come here and give us a first insight into the implementation of this package tour directive in Germany. You can already tell that there are many unanswered questions, but I would still like to point out that Mark van der Waal will be speaking in the hall Regensburg, and he will explain the details of his concept in a few moments' time. With that, I would like to thank you for your attention and enjoy the remaining sessions.